Ted Visner again. I just wanted to reiterate a couple things with regard to the videos I just put up. In 2010, Shelley Sweet and the Isabella County Sheriff's Department stole our house and its contents. Okay, Shelley Sweet was an employed member of the Isabella County Sheriff's Department, and the Sheriff's Department was not willing to help us with this issue. Obviously, well, they should have, but they didn't. And it took a long time to figure out first that Shelley Sweet was in fact an employee, because they hired some lawyer that said he represented all of the people from Isabella County and the county itself, but did not represent Shelley Sweet. So there was deception right out of the gate with regard to Shelley Sweet's employment with the Isabella County Sheriff's Department. Well, now that's known. That's discovered. That's known. It's in the court paperwork. What's been bothering me really is why the Sheriff's Department wouldn't respond, why the Michigan State Police wouldn't respond, and it all boils down to one thing. A Mount Pleasant lawyer by the name of Bruce Havens committed fraud upon the federal court when he filed a notice of intent to sell and take possession, and filed that in the federal court as a standalone document to be executed 5 days later. And at an objection hearing to that filing, after the intent of that filing had already been carried out, which was the transfer of possession of the house and its contents to Shelley Sweet and God knows who of our house in 2010, the issues related to the creation of a fraudulent document filed in the federal court, the fact that the federal court judge, Daniel S. Opperman, on his own initiative at the objection hearing to this erroneous filing by Bruce Havens, called it a motion. Okay, lawyers file motions all the time, and when they file a motion, they always schedule a motion hearing. This was filed without scheduling a motion hearing, folks. This was filed as a standalone document. Now, on Monday, September 20th, 2010, Bruce Havens filed his notice of appearance on behalf of Shelley Sweet as a creditor in our bankruptcy, listed in our bankruptcy. And approximately 30 minutes after that, Bruce Havens filed this notice of intent to sell and take possession of my family's home and its contents. 36 minutes, I believe it was, after he filed his notice of appearance on behalf of Shelley Sweet. The signature block on his notice of appearance said, attorney for Shelley Sweet, and respectfully submitted. Okay, and that was filed first. And then 36 minutes later, this notice of intent to sell, take possession was filed in the federal court, and his signature block was changed. He did not state that he was the attorney representing creditor Shelley Sweet. That was just missing. And it didn't say respectfully submitted. So with these two items missing on this fraudulent, blatantly fraudulent, prophylactic, Bruce Haven called it at the hearing, it's blatantly obvious that Bruce Havens created this document to look like a signed federal court order. And that's how it was used. So when I say we're coming full circle here now with knowledge and information with regard to what's going on here and why the Sheriff's Department and the State Police are not acting in any lawful manner on our behalf or with regard to investigating what's going on here, we have to understand what we've just uncovered. Okay, what we've uncovered is some sort of scheme between lawyers and federal court judges with regard to bankruptcy and bankruptcy stays. They've created a means and a mechanism by which the stay of bankruptcy can be avoided, so that essentially nullifying a bankruptcy stay. This is heavy stuff, folks. A stay of bankruptcy stays everything, okay? And everybody knows this. You know, you can't be evicted from your house. You can't lose your house in a foreclosure unless you run into the bastards I've run into. Bruce Havens and Daniel S. Opperman, federal court judge. This system they put in place, Bruce Havens filed this notice of intent to sell, take possession, not as a motion, just as a bullshit filing that didn't mean anything to anybody but him and Shelley Sweet. And then they printed that federal court filing and presented it as if it were a federal court ordered eviction signed by a judge. Okay, a couple things. Either Daniel S. Opperman is not qualified to be a judge, or he's playing games with the system. And between him and Havens and God knows how many other lawyers, they've got this scheme set up where if somebody from the state, like Shelley Sweet, worked for the sheriff's department, so she was kind of allowed to use this mechanism to screw people out of their house and its contents because she worked for the state. That's where all the indicators are pointing right now. Okay, it's having seen it firsthand, it's wicked. It's totally wicked. A lawyer files this document in a federal court bankruptcy case that basically nullifies the stay of bankruptcy and actually creates a federal court eviction signed by a lawyer. It's not even reviewed by a judge. There was no hearing associated with this filing. It was a standalone filing that meant nothing to anybody except Bruce Havens, Shelley Sweet, and the Isabella County Sheriff's Department. And they used this bullshit filing by Bruce Havens as though it were a federal court-ordered eviction to take my family's house and its contents on the weekend prior to September 27th, 2010. This is a full circle thing here. Okay, we're coming full circle. If a federal court judge is actually involved in the deprivation of due process and between himself and his lawyer friends or whatever, they've developed this scheme using federal court filings to circumvent and completely bypass a bankruptcy stay. Now we can understand why the Sheriff's Department won't help us. Now we can understand why the Michigan State Police won't help us. Now we can understand why federal authorities aren't willing to help us. Now we can understand why Bill Schuette and the Michigan Attorney General is not willing to help us. I've got a federal court judge by the name of Daniel S. Opperman and a lawyer by the name of Bruce Havens creating workarounds for a bankruptcy stay for state actors, for people who work for the state. So their property has never stayed in a bankruptcy. And they get to just have their way with the property and completely circumvent the judicial process. This is huge, folks. This is huge. I'm going to be working on an audit in conjunction with some friends to see how deep this goes, to see how many of these notice of intent to sell and take possession of people's property have been filed by the federal court, and how many of them have been signed by Daniel S. Opperman, and how many cases went through. Daniel S. Opperman didn't even sign the notice of intent to sell, take possession. That was signed exclusively by Shelley Sweet's lawyer, Bruce Havens. But Daniel S. Opperman, the federal court judge, allowed this to happen in his court. This federal court fraud was allowed by a federal court judge. Any kickbacks there? Any financial motives there? What's going on? This certainly explains the lack of interest with any law enforcement involvement with regard to the theft of our home and its property in 2010. Hell, our state representative, Kevin Cotter, wouldn't touch us with a 35-foot pole. Do we know why now? Yeah, because, well, to bring all this stuff to light, we have to say what happened. And what happened was federal court fraud right under a federal court judge's nose, and the federal court judge called it a motion, when the only hearing regarding this notice of intent to sell and take possession was an objection hearing filed by me. So there you have it, folks. The loss of our judiciary. Tell me where it ends. Show me where it starts. Show me where it ends. It doesn't end. Stay tuned. There's going to be more to this story for sure. I can imagine that we're going to uncover some things here that are going to curdle milk on the table of every American right here in Michigan. More later.